Let's move over to the next topic. That's judiciary and the conflicting court orders. The Chief Justice of the Federation and Chairman of the National Judicial Council, Justice Tanko Mohammed, has summoned the Chief Judges of 6 states over conflicting decisions, all given by Court of Coordinate Jurisdiction. And the Chief Judges summoned are that of Rivers State, Kebbi State, Cross River, Anambra, Jigawa, and Imo State. Gentlemen, we discussed this issue last week. Was it last week or 2 weeks ago? About conflicting court orders. Sincerely, what do you feel? Now, you know, one of our discussion that day was that the CJN should do something. And someone sees
of the chief judge of the respective states
to come and talk about this thing. And because I remember some of your colleagues talking about that it's shameful that this is emanating all the time. And political people, that the politicians are the ones are always engineering this. So what's your take with this invitation? And do you think that will be the last of it?
Well, it's not likely to be the last of it.
Wow.
So long as this democracy remains the way it is and goes on this way and all that, you could be assured that politicians will always want to abuse the court process to achieve whatever ends they might have in view. Let me quickly say that ordinarily, a court order, whether interim or substantive, shouldn't have been an issue per se. I give you an example. Some of my friends who practice in the US, for example, practice in Britain and what have you, will tell me there were times they would even on phone call a judge and say, look, my lord, a client of mine who is been alleged to have illegally entered Britain is about to be deported by the immigration. I would urge my lord to please give me an interim order restraining the immigration people from deporting the person. And then the judge on phone, not any physical contact and what have you. And then the judge will ask you a few questions and also attach some conditions to whatever order that might be given. And once you say you want to abide or you are ready to abide by that, they give you those orders and what have you. Where it becomes problematic in our own case, and the reason why society allows such orders to be taken or to be given is that we want to encourage people not to engage in self-help, that you don't shut the door of the justice system to people, because if you shut the door, you might be encouraging self-help, and when you have self-help, then you find that anarchy and chaos might be at your doorsteps. But just like we said, what is the challenge that we do have in this system? The challenge that we have is that most of the court orders, especially those conflicting court orders that we have in this country today, are basically or majorly emanating from political cases. They are coming from politicians. It's like when a politician has gotten a decision that doesn't favor him in court A or court B, he rushes to court C to go and shop for a favorable decision. And then the court will open its door to such a politician and then give them whatever decision that they would want to have in some of those cases. So it's both the fault of we, the lawyers, who in the first instance know that certain things are not proper. And for reasons best known to us, we still approach this court and then insist that this order should be given. The judges are also not to be exonerated. In order proper case management and all that. If a court manages his case properly, and if the judges who are giving some of these orders will abide by the rules of giving some of these interim orders and all that, you will find out that some of these interim orders wouldn't be flying at the rate at which they fly, and then they wouldn't be as contradictory as they have become. In most of these cases, like I said, conditions are supposed to be attached to some of these things.
Okay, I wanted to ask that point that this ex parte motion supposed to last for 7 days.
Exactly.
Can't we
What most
wait-
14 days.
Can't we wait 7 days before we file any?
Just like I said, one, we don't want to encourage anarchy and say that. Secondly, certain issues, certain tribal issues sometimes could become, so to say in quote, perishable.
Okay.
They become perishable. So that if you feel that Mr. A wants to kind of
Stop you
breach
from
of
doing
fundamental right, or certain things would happen that money cannot compensate for the damage that would have taken place within that 7 days. If the order is not given, then the court will want to be disposed to listen to you. But like I said, certain conditions must be attached to it. But here we don't attach any too much condition. In some jurisdiction, they could even ask you to put down money, to pay certain money into the court registry, and that if the case doesn't favor you, you lose the whole of them, and that money can be quite substantial. Furthermore, the judges by now ought to be attentive and alive to the antics of the Nigerian politicians.
Yes, I was coming to that. Barrister Chime. One thing that when the last one that happened, that's the one that was filed in Delta, one thing that came to my mind was that why didn't the judge ask if there was any case on this matter before? Because normally when there is a case has been instituted, if you want to seek redress, you go to the higher court to get what you want to get. But why is it that the judges cannot find out? Because what comes to mind is that whether they were paid to quickly give that ex parte motion.
Okay, let me start by making this adage that if we must blame a kite for carrying the chicks, we must first of all blame the mother hen that exposed them to the enemy. The point is that we must situate the blames where it is. The ex parte orders granted by several courts, one from Rivers, I'm talking in respect to the one restraining the
PDP
chairman of
the River State, and 3 days after that order was paid on 23rd of last month or thereabout, and 3 days after we have another order in Kebbi State, you know, trying to restrain or stay the execution of an order of another court of coordinate jurisdiction, and subsequently we have another order in Cross River State, also restraining the PDP chairman. So these are funny developments, but it is not unconnected with political desire of people to ascend into power by all means. Now, the problem is from the lawyers, not necessarily the judges. These are seasoned lawyers, most of them are senior advocates that institute this action, knowing fully well that another court is seized of the facts. They will be window shopping, trying to get favorable orders to return their own candidate. So I think the first blame should go to the lawyers first and foremost, those who have abused the process of court. Because if I'm a judge, I can only be aware of facts presented before me by litigants. Judges are not superhumans to know what is happening in another court. And that is why I queried the rationale behind the CJN summoning the head of courts of those places where these ex parte orders emanated from. Because why not invite those judges that gave those orders? If you are the chief judge of a state, your order is as good as the order of your learned brother judge in the same state. The head of court is for administrative purposes. It does not make the order of a CJ superior than other judges. So the point is that I do not see the connection between inviting the heads of court of different courts by the CJN, leaving out the judges, those that actually gave those orders, particularly with respect to the order from Kebbi State.
Yeah, but they feel that the head of the court in those states could call those judges to order. You know, if you call those ones that have given the case, if another person now gives another ruling in the same states,
how do you call him to order?
So
no, that's the question. How do you call him to order? what the CJ does of every state is to assign matters to different judges in court. The CJ may not be privy to the facts and circumstances of each case. So how do you begin to call a judge to order for delivering judgment based on the fact presented before it? That is the question. So the NJC has a statutory responsibility, I agree, to discipline erring judges, and the CJ is the head of that agency. It will be well within his right to decide who to invite or who not to invite. But my point is that if a judge gives a judgment, it is only that judge that can defend the judgment he has given. The CJ, the chief judges of those states, cannot be in all the courts in his state, determining the kind of nature of orders emanating from which court. It does not work like that. So if the courts in was in River State that restrained Secondus based on facts presented before it, whether rightly or wrongly, that order must be obeyed until set aside by a superior court. But where the problem is where you have a court of coordinate jurisdiction. What we say coordinate jurisdiction, high court, they are the same pedestal.
Yes, the same level.
Giving order, restraining or suspending the order of another court of coordinate jurisdiction, that is judicial rascality. That is where the problem is. Then, as to whether ex parte orders can be granted by courts, the answer is yes. Based on circumstances of every case. Each case is authority for what it decides. So if in the wisdom of the court, based on facts presented before it, it feels that there is need to protect and preserve the rest, ex parte orders could be given to last for 7 days or thereabouts. But where it has been brought to the attention of another court of coordinate jurisdiction, because if you, I'm particular about the rascality involved in the Kebbi State High Court. I'm not even talking about what led to what, or who is right or who is wrong. How can a judge of another state give an order, like suspending or restraining an order of another court from being executed? It's like a stay of execution. It doesn't work. It has never, that is not the principle of any law known to Nigerian law. So these are issues. Much as some blames will go to the judges who gave those orders, they should be in a better position to explain the wisdom behind that. But I think the bigger problem and bigger issue lies on the lawyers. They are the ones abusing the court process. They are the ones instigating this crisis in Nigeria. And just like Supreme Court has said in one case, that those who have benefited from the benevolence of judiciary must resist the temptation of emasculating it. It is not uncommon to see this type of orders, coming left, right, and center during the electionary process. Because politicians are a desperate set of people. It is that they win or no, or they rubbish the entire system. So this is where the judiciary must be careful in the nature of cases and orders that they give. For me, because the matter is in court, I don't want to go into the reasonability of those orders granted.
Barrister Palawole, I wanted to find out from you what will now be the solution, because from what your learned colleague said, he was saying that lawyers, they have their own paths. What on the level of MBA, what will be the solution to this?
Well, there are a series of solutions, not just on the part of the MBA alone, but on the part of all those who are stakeholders in the Nigerian justice system. You will recollect that when I was doing my own conversation, I mentioned case management.
Yes.
What do I mean by that? A federal high court sitting in Lagos here does not know what the federal high court in Abuja is doing. The National Industrial Court here in Lagos will not know what the National Industrial Court in Jos is doing. Whereas with the state of technology today, there ought to be a digest of cases before the court in which the judges should be able to sit down and punch the computer and get whatever information that they want regarding whatever new matters or especially controversial matters that have been filed before them. But you see, we have been doing the computerization process in the Nigerian court now for more than 15 years. And it's even more problematic now to file cases and deal with cases than when we were doing it manually. That is a tragedy of the whole thing. So we must address the issue of case management in Nigeria here at both the state level and then at the federal level. And with regards to the CJN calling the chief judges of all these states and all that, just like my friend said, that is totally uncalled for. When Honorable Justice Nogin was there was a direction with regards to all these frivolous interlocutory this thing. The man before him also called attention of the judges to all these things. It is time now for people to, for the chief judge, for the CJN to apply the sanction. There are so many party directions and orders from my lord the chief justice who were there before Honorable Ways. I mean, Tanko and all that. So calling people for any discussion with regards to these frivolous orders and applications that we are getting from those places isn't really coming. Furthermore, I think the challenge also has to do with the appointment of judges in some of these places. The man in Kebbi that we are talking about that we vilify or we are not comfortable with whatever the has gotten, he probably got on to the, with due respect, so long as the executive arm of government continue to have a say in who gets appointed as a judge, as a magistrate, as a president of the customary court and order, and also insist on holding on to the wall and on holding on to the finances of all these courts and order. The kind of conflicting decision that we continue to see in some of these places must be there. So we must make the appointment of judges independent of the executive arm of government, so that we could begin to have some sanity, and then the judges will not have the fear that if they don't give a favorable ruling or decision in support of one party or the other, the fear will not be there. Look at it, just a minute, look at the judge who was retiring. I think it was Delta Olivers and all that. And so because he gave a decision against one of the security agencies and all that, and they were going to his house and this to harass him. To harass him. And these are people who should be protecting the judge and not the ones sending evil thugs to come and start harassing the judge simply because the judge gave an order that was not favorable to that agency. With the NBA discipline, the mechanisms are there for both lawyers to be disciplined, just as like the National Judicial Council also have mechanism for discipline judges and other. Too many times, those who should pursue the discipline of both the judge and the lawyers and all that don't usually want to do it. And in fact, immediately they initiate it and all that, you find out this same society will start prevailing on the you will destroy this Mr. A's career, or you will do this and that. He is your kinsman and what. So a lot of religious sentiment, tribal sentiment, and political interest will come in there, and then the whole thing is not carried on to its logical conclusion.
Maybe a quick one from you. How do you think we could resolve this?
Yes. Okay. Just for what my learned friend has said, we should begin the disciplinary mechanisms provided under the rules. Legal Practitioner Disciplinary Committee has the responsibility to discipline erring lawyers who are found breaching the rules of professional conduct. So if these senior lawyers are derobed or their ranks removed from them, I think it will go a long way, in teaching others lessons that there's consequences for actions. Then on the part of the judiciary, the judges themselves, I think one of the major problems we have in Nigerian judiciary is that politics has somehow permeated deeply into the annals of Nigerian judiciary. You find it difficult to distinguish judiciary from the executive, even from the workings of judiciary. Appointments. You see that most people who eventually get appointed are cronies with respect, without prejudice to the integrity of judges we have in Nigeria. But many of them are cronies or loyalists to politicians. So most times, when the politicians get to power, become governors, they'll be in a better position to influence who becomes a judge in their own state. And the thing, it cuts across every other state in Nigeria. So with that, it will be difficult to remove that loyalty from that politician when the need arises. So it's a very big challenge. Secondly, we must have a new way of appointing judges in Nigeria. The system, the judiciary has been ridiculed more than ever before in the history of this country. And we must begin to revive the image of the judiciary. Yes, the knowledge-wise, because I think sometimes ignorance is a problem. Ignorance of a judge is a calamity to the innocent.
Wow.
So most times these judges, with respect to them, may have given a judgment without knowing what to do in a particular situation. So we have so many issues confronting us, but we can start somewhere. From appointment and discipline, we must make it a duty. Nobody should be a sacred cow. We use people as scapegoats, irrespective of your position in the society. If you're a lawyer and you went and filed an action in KB High Court, trying to set aside an order of another court or coordinate jurisdiction, does it make sense? That's judicial rascality.
Okay.
An abuse of corpus. So we know how to get it right. But like I always say, issue of a willingness to fight this thing is the problem, because eventually you find out that those who even have the responsibility of ensuring those discipline are also caught up in a way.
Wow. Okay.